All right, good morning, everyone. This is Gary Phillips. I'm going to wait 30 seconds or so before we get started, just to allow the attendees to join. Okay, I think we're going to get started. Good morning to everyone out there. Thanks for listening in and watching virtually, presumably from home during these unprecedented times. My name is Gary Phillips. I'm joined by my partner, Mary Browning. Hi, Mary.
Hi, Gary. Hi, everybody.
We are both partners in the Tax, Trust, and Estates Department at Schotz. I'm based in New York, and I'm sitting in New York City right now. Mary's based in and sitting in New Jersey right now. First and foremost, we hope you and your families are safe and well in these unsettling times. That actually is the most important thing. The COVID-19 crisis has been ongoing now for over a month, and we've been working throughout, addressing all of our clients' questions and concerns as it relates to estate planning. We've addressed a lot of specific questions, and we thought it would be a good idea to put on this webinar to address the issues we have heard and dealt with over the past month, so you can plan accordingly for yourself and for those people who have clients, your clients as well. Basically, the topics we will discuss fall into two general categories based on what we've been discussing with our clients. The first, one common theme, is the idea of just getting your affairs in order. As scary as that sounds, we fielded a lot of questions along those lines, so we'll discuss what that actually means and the decisions you need to make. The second is we'll discuss planning opportunities that have arisen as a result of the crisis, and there are important opportunities to mention. They may not apply to everyone, but for the people it does apply to, it could save significant money. Believe it or not, we begin, however, with a topic Mary and I never really had to pay too much attention to, but it has been one of the main topics of discussion over the past month. My career, over 25 years, and Mary's career, 15 plus years, we've really never had to focus on this, but due to the fact that we're basically confined to our homes, a major issue is how to execute these planning documents. You go through presumably the harder task of meeting clients and developing a plan and drafting and finalizing decisions and finally drafting the documents. You have the documents done, and now the problem is we can't execute them. So we want to discuss and have a conversation with what we've been dealing with over the past month or so to deal with this problem. So that is where we'll start. One housekeeping item: if you have questions, there's a question button at the bottom of the screen. You can type in questions. We can try and address them during the webinar. If we can't, you can certainly email Mary and me at our email addresses. We'll be glad to answer anything after we're readily accessible. So with that, I'm going to pass it over to Mary. We're going to talk about first how to execute your documents during this crazy time.
All right. Thanks, Gary. Okay, I'm going to start with New Jersey. Every state has significantly different rules when it comes to how to execute certain legal documents and what makes a document binding under the statute. So Best practices, and this is best practices that our firm follows and a number of other firms follow, which in some cases is more than is required by the statutory rules. But typically what we recommend when we help our clients execute documents, and typically this is done in our office where we have plenty of notaries and plenty of disinterested witnesses, is all of these documents, the wills, trusts, powers of attorney, healthcare directives. We have 2 witnesses who are disinterested, meaning that they're not either beneficiaries or they're not named in the documents in any kind of roles. We have the 2 witnesses and the notary sign. For a deed, what's required in New Jersey is a notary. We often have a witness sign as well. So under what I call normal times, that is what we do. And as Gary said, we very infrequently have had to think about what's the minimum amount needed, because it's just typically not an issue for our clients to come to us or us to go to our clients in person. But because of this, this situation, and because frankly, every one of our clients has a unique situation. Some are at home alone. Some are at home just with their spouse. Some are at home with their kids. Some are at home with extended family and others. So it really, number one, depends on everyone's unique circumstances as to how we can get these documents executed. I'm going to talk about what the minimum amount that's required under the statute, and then we're going to talk about what if you can't even meet the minimum, what can you do in that scenario. So in New Jersey, to have a valid will, it has to be signed by the person who's creating the will, and it has to be signed by 2 witnesses. And those witnesses don't need to be necessarily there with the person when they're signing their will. So if I'm signing my will and I'm by myself, I can go ahead and sign my will, but within a reasonable period of time, or at the same time, if you happen to have a situation where witnesses are available in person, you need to, in view of the witnesses, not via video or FaceTime, but actually physically being able to see the witnesses, you need to tell the witnesses that this is your will, that you know this is your will, that this is in fact your signature, and ask that the witnesses affix their signatures to the document, witnessing that either 1, you're signing the document in front of them, or 2, that you acknowledge to them that you signed the document in the recent past. Certainly, if you're comfortable with social distancing, you can have neighbors, for example, serve as witnesses. If you are comfortable, I had a client the other day who was comfortable with taking the documents, putting them on the front porch of their neighbors. They went back to their porch, the neighbors came out and took the documents, and they had a conversation from afar, acknowledging these steps that I just went through. Sometimes people are comfortable doing that, and sometimes they aren't. But if you are, that's a process that certainly we would recommend that you do. In New Jersey, interested witnesses, which typically include beneficiaries. So for example, if you have a spouse or you have a child who's over 18 at your house, then they could sign as witnesses. And in New Jersey, that does not invalidate a will. So if you have a situation where you're leaving assets to a spouse, and at the spouse's death, everything goes equally to the kids, what I would call a, kind of a non-controversial scenario. You're not leaving a child out, you're not giving more assets to one person over the other, then having an interested witness sign certainly would make the will valid. If you have a situation, or your clients have a situation where, let's say there's one child that's being left out, and the child that's receiving everything is the one that's in the home and acting as a witness, although the will potentially, or at least on its face, would be valid, that's certainly not ideal, because obviously if that person were to die before this will was re-executed with disinterested witnesses, there's certainly an argument for the child being left out to make that their sibling was influencing the parents, and you know, the fact that they're signing as the one witness is not a good fact. But in the, what I call, again, the non-controversial scenario, that's certainly an option if any of your clients or you have people available in your household. So assuming that a will has been signed by the person creating it, and assuming that it's been signed by 2 witnesses, at that point, it is a valid will. If nothing else happens, if nothing else is signed and someone dies, that will go through probate in New Jersey, in the county in which the person resides. But if there is no self-proving affidavit, which I'll explain in a moment, if there's no self-proving affidavit attached to the will, there will be additional steps that will need to be taken in order to probate the will. And typically what the requirement is that at least one witness to the will need to submit an affidavit to the surrogate's court when the will's probated. And that affidavit essentially says, I witnessed the testator sign the will, or the testator acknowledged to me that he signed the will last week. I saw the will, I saw his signature or her signature. And in fact, I was there in person, and that's my signature. And I'm affirming to the court that this was all properly done. Certainly, if someone dies in relatively short time after a will is signed, presumably the witnesses are still where they were, across the street or in the house. And that step of having the affidavit signed and submitted by the witness is not particularly onerous. However, in other situations where a will may be signed and several years have passed, and either the witnesses have also died or become incapacitated, or you can't find them, then that scenario becomes much more problematic. So the way to resolve that, and again, this is something that we always do when we have clients sign wills, is to have the witnesses and the testator in front of a notary sign what's called a self-proving affidavit. And what that is essentially you're preparing the affidavit that normally would get submitted to surrogate's court when someone dies. You're essentially, at the same time that you execute the will, you're signing this affidavit that says, I signed it, the witness signed it, the witnesses are affirming that the testator signed it in front of them, or at least acknowledged in front of them that they signed it in the recent past. And that document has to be notarized. So certainly to the extent that a notary is hard to come by, and in New Jersey, what we're seeing is that seems to be the most difficult person or slot to fill, because we may be able to have neighbors, we may be able to have other family members signed as witnesses, but not a lot of people have notaries available to them in their household or across the street from them. So if you can't do the self-proving affidavit now, but you can sign a will and you can have 2 witnesses sign, the self-proving affidavit can be done at a later date. And so if you sign the will now, and a few months from now, hopefully when things get back to normal, and at that point there's a notary available, you can have the self-proving affidavit done then.
Mary, I just want to jump in. I just want to add 2 points. The first is just a note that attorneys in New Jersey are notaries. So, if you have an attorney as a neighbor down the street, that potentially could be, that attorney can serve as a notary, even though they're, attorneys automatically are notaries. So that may be an option for somebody. And Mary, I'm just going to read you a question that came in. So we'll address it as I'm reading it. If it is a New Jersey will, can my witness, and this is from Janet, if it is a New Jersey will, can my witness live in New York? Since I live right on the border to New York, also can the two witnesses be related to each other? So the answer to the second question, can the two witnesses be related to each other? The answer to that is yes, because interested witnesses in New Jersey are okay. The idea of can the witness live in New York? You may have a problem with the self-proving affidavit because the notary has to be, notarize both witnesses. But if the witness, if you take the document over to New York and acknowledge that signature, that should be okay.
Right, I agree with that. The witness being in New York, if they're down the street from you and you're talking to them from New Jersey, that's not an issue. The issue would be with a notary, because a notary is only allowed to notarize documents if they're in the same state where the person is that's signing. But for purposes of signing the will in front of two notices, that's perfectly fine. Okay, so let's then move on to trusts. And certainly we're going to go into in a few minutes about, using the use of revocable trusts and the difference between revocable trusts and wills and how they work together, and why revocable trusts during this time period may be very helpful for some clients. We will talk about that, but trusts in general in New Jersey, whether it's a revocable trust, whether it's an irrevocable trust that's used for life insurance or gifting, in New Jersey is actually very simple to satisfy the legal requirements. It only has to be signed by the grantor or the person who's creating the trust. Although ideally, we like to have those documents signed again in front of two witnesses and a notary. If it's signed by the grantor in New Jersey, it's a valid trust. Yesterday, I had a client who needed to sign a trust. She had one witness available in her house, so she signed it in front of a witness. And her brother, who's serving as the trustee, he will sign it. He's going to be available to sign it in a week or so, but I'm just having essentially whoever can sign it with as many witnesses as possible. But once she signed it yesterday, it actually became a valid trust. Powers of attorney in New York, New Jersey, Florida, where we also practice, and likely other states around the country, does have a requirement that it be signed in front of a notary. And typically that's the only requirement. But unfortunately, there's no alternative to having the notary sign the power of attorney. So you can't have two witnesses sign and hope that that takes the place of the notary. So the power of attorney, which is a document where you appoint someone to pay your bills, handle your finances, deal with your businesses, anything financial that you handle now, that if you became incapacitated, you would need someone else to step into your shoes. That document requires a notary to sign. So in New Jersey, unless, as Gary said, you have a notary or an attorney who lives nearby, that document may be difficult for people right now to have signed. Medical directives or healthcare proxies in New Jersey have to be signed by the client and either two disinterested witnesses or a notary. And in this situation, a disinterested witness is just defined as someone who's not appointed as the one making healthcare decisions. So if you have a husband and he appoints his wife as the first person in line, followed by his daughter, then anyone can witness other than his wife or his daughter. So it can be other family members. Again, it could be neighbors. And fortunately, the medical directive does not require a notary because understandably, this is a document that a number of people are concerned about making sure that they have in place during these times. And then the other document that we often see executed for estate planning or deeds. A deed in New Jersey has to be signed in front of a notary. So again, like the power of attorney, unless you have access to a notary, that deed at this point is not going to be legally binding. We have been hoping that New Jersey will enact, some states have enacted executive orders that have been allowing notaries, and in some cases, witnesses, to essentially watch the signing and hold an execution ceremony for these documents on video. Some states, and New York is one of them, which we're going to talk about in a moment, New York has enacted such a rule for notaries, but not witnesses. New Jersey, it's been discussed that they're going to allow notaries on video calls. That has not yet been enacted, and based on the draft of the order that I've reviewed, it would not allow virtual notarization for wills. Other states, Connecticut just passed a rule last week allowing for virtual notaries and virtual witnesses. We are very hopeful that New York and New Jersey and Florida will eventually, hopefully sooner rather than later, enact similar rules. But unless and until they do, what we've been telling our clients is do the best you can under the circumstances. So if you have, ideally, witnesses, even a notary, great. We can essentially have your documents executed similar to how they would be executed if you came into our office, albeit, you know, from across the street, and, you know, maybe with using your own pens and whatever you feel like you need to do to be careful. But those are the easier cases. The more difficult cases are, you know, I'm by myself. I don't have anyone in my household. I don't feel comfortable either going outside, you know, asking my neighbors to do this. What do I do? And I had a client who called me the other day in this very scenario, and he said, I didn't know what to do. I just signed my will. I don't know if it's going to be valid or not, but I signed it. I don't have any witnesses. I don't have a notary. And in my opinion, and, you know, in the opinion of a lot of other trust and estates attorneys around the country who are finding themselves in this same situation, I'd rather have a client sign the document than not sign the document, because at least if they sign it, and in the worst case scenario, they die before we're able to have it executed properly, I know that at least I could make an argument to the surrogates court that this was the document that he intended to be his will. He signed it, and this is what he wanted. So we should, you know, under the extraordinary circumstances of COVID-19, we should respect his wishes and probate this will. It'll be difficult, likely, and certainly more expensive and time consuming than if the will was properly executed. But in my opinion, it's better than not signing it at all. So the theme for really any state that you live in or practice in is to do the best that you can under the circumstances. In that case, I was on, he did not have video conferencing, but I asked him to call me while he was signing it. So at least, again, if this had to go to the probate court, I could attest to the fact that I was on the phone with him. Do the best you can, even though virtual witnessing is not yet technically allowed. I'd rather have someone sign a document and have two virtual witnesses watching them than have them sign alone. So do the best you can under the statute to follow the rules. And if that's just impossible, then get as close as possible under these circumstances. And certainly as soon as life gets a little bit back to normal, everyone should just re-execute the documents using the notary and the two witnesses. So briefly with New York, it obviously has a lot of the same circumstances that New Jersey has. New York's rules are similar for certain documents. Power of attorney requires a notary. The medical directive, just again, two disinterested witnesses. The deeds require a notary. A will, similar to New Jersey, as long as it's signed by the testator and signed by two witnesses, it's a valid will. The self-proving affidavit is also recommended. New York is different in one way when it comes to witnesses. Unlike New Jersey, where interested witnesses don't invalidate a will or a bequest, what the law says in New York is, if a witness signs and the witness is a beneficiary under the will, then the witness may be limited in what they receive to what they would have received had there been no will. And I don't want to go too deep in the weeds on this, but to give you an explanation of what that means, in my scenario where there were two kids and one child was being cut out and everything was going to the other child, if the child that signed as a witness is the one that was supposed to receive everything, what this rule in New York would do is it would say, if your parent had no will, everything would have gone 50-50 to the two kids. So because you signed and you're an interested witness, you're only entitled to receive 50%. So in New York, it's certainly better to have a disinterested witness sign. But again, if you have a situation where everything's going equally to the kids and the kids are the only people you have that can sign as witnesses, again, in my opinion, that's certainly better than not signing it or not signing it in front of any witnesses. Trusts in New York, unfortunately, have additional legal requirements as opposed to New Jersey. In New York, it has to be signed by the person creating the trust in the presence of two witnesses or a notary. And at least one trustee has to sign unless the person that's creating the trust is the sole trustee. New York has enacted, actually it was one of the first states to enact an executive order allowing for virtual notaries. So the notary has to be located in New York and the person signing has to be located in New York. But otherwise you can have a video conference with a notary and you can take care of signing at least some of these documents just in front of the notary. You still, for a will and for the medical directive, have to have disinterested witnesses in the case of the medical directive and ideally in the case of the wills. But certainly the virtual notarization in New York is at least a step in making sure that some of these documents can get signed under these circumstances. So again, the theme is do the best you can do. Everybody's situation is a little bit different. And most importantly, once everything gets a little bit back to normal, everything should be re-executed just to make sure that there aren't any stumbling blocks down the road. All right, Gary, you want to talk about revocable
Okay,
trust?
Mary, thank you. I'm gonna wrap the revocable trust conversation into the basic planning documents because A common call we're getting from clients, again, in these unsettling times is, look, I've delayed planning, my affairs and dealing with my estate for a long time. This is an unsettling time. I need to deal with it. So, help. What does that mean? So what that means to us is, making sure you have your will in place, your power of attorney in place, and your healthcare directive in place. And what we've found and what has been magnified as a result of this crisis is, the use of revocable trusts as an alternative to wills. So, in terms of the things, we discuss with clients the topics and the decisions they need to make. Typically, we break it up into two categories, and I like to break it up into non-tax common sense categories and tax categories. So when our clients are calling and saying, okay, we need to get our affairs in order, and we mentioned to them, okay, we're going to draft, you need to have a will, the decisions to make are, all right, who are your beneficiaries going to be? Okay, so if something happens to you, you pass away, where do you want your assets to go? And look, a lot of it is most of the time it's easy decisions to make. If the client's married, I leave everything to my surviving spouse. If my surviving spouse is not alive, I leave it to my children. If my children aren't alive, I leave it to my grandchildren. Guardians. Clients are calling and they have minor kids. God forbid something happens to mom and dad. Who's going to be the guardian? Who's going to have custodial rights to care for the minor children? So that's something that all gets taken care of in a will. And in a minute, I'm going to talk about how we're shifting to revocable trusts. When assets pass to children, does it make sense to have assets pass outright to children? In our experience, the assets, it makes most sense to have assets pass in some type of trust for a child. So when the conversation of trusts comes up, question then is, who's going to be the trustee of the trust? Who's going to be in charge of it? So decisions as to the identity of who the trustees are. The person who's in charge of the estate when someone passes, that's the person known as the executor. So who's in charge of the estate? A lot of times, whoever the executor is also the trustee. A lot of times who the executor and trustee, they're also the guardian. But sometimes for a family, it's a personal decision. It's not a legal decision. It makes sense for one person to be a guardian, to have other people be the trustees, so they're working together. Another decision to make, God forbid there's a disaster and the linear family is not alive. Who are the ultimate contingent beneficiaries? So those are the non-tax decisions that a client needs to make in order for us to draft a will. What we have found over the past couple years is that the main document we're drafting is now a revocable trust, a revocable lifetime trust as opposed to a will. Florida, because we have an office in Florida and we practice in Florida. In Florida, people have been using revocable trusts for a long time. In New York, I would say in the past 2 years, we have migrated over to having our clients use revocable trusts. And in New Jersey, this may be the shift to revocable trusts. The main driver of the shift from wills to revocable trusts is the concept of probate. And the idea is, if you have a will and let's say you have a bank account, an investment account, and a piece of property in your name. When you pass, an estate is created, and an executor needs to be appointed to take charge of those assets. In order for the executor to be appointed, your will goes through probate in the county court where you lived. That process takes time. And now in COVID-19, the courts are closed. They're not taking paperwork. They're not taking applications. we've had a few of our clients unfortunately pass away during this time, and now we're in a state of limbo because probates are delayed, are not happening, or postponed. So fast forward back to the assets, there's a bank account sitting there that it can't be accessed. There's an investment account that's invested in a certain way that has a financial advisor that no one can talk to the financial advisor because there's no one in charge of that account. So now this crisis hits, there's investment decisions that need to be made, and no one can make those decisions. So how do we fix that? We fix that through the use of a revocable trust. And the idea is this: a revocable trust is essentially a will substitute. All of the key provisions, who your beneficiaries are, the trust for your children, the trust for surviving spouses, they're all built in your revocable trust. But while you're alive, you put your bank account in the trust. You put your investment account in the trust. You deed your property into the trust. So what happens here is it's now owned by the trust. So when in the future you pass away, the successor trustee of that trust has immediate access to those assets. There's no requirement for a court proceeding to get an executor appointed to deal with that asset. And while you're alive, the revocable trust is yours. You're the trustee, you're the beneficiary, it's completely revocable. So if things change, you can modify the revocable trust. It's almost as if it's your alter ego. So the clients who have, in the future pass, their family has immediate access to the money. There's another reason for this also. Another beneficial use of revocable trusts. In many wills that we draft, there's trusts created within those wills. They're known as testamentary trusts. And a lot of times there's trusts built in for surviving spouses. There's trusts, as I explained, there's trusts built in for children, for grandchildren, and these trusts can last a long time. If there's a trust for a surviving spouse, and that surviving spouse's trust is invested in the market and has, it's a financial asset, and the surviving spouse then dies, in order for the successor trustee to come in and be in charge of that, because it's a testamentary trust, a court proceeding is required. And it's not typically, a difficult court proceeding. And in Florida and New York, it's more difficult than New Jersey. But there's court authority is needed to grant the successor trustee power over that testamentary trust. If instead all of those trusts are built within the revocable trust, when the trustee passes away, just by virtue of the trust being in the revocable trust, all that's needed is the successor trustee signing an acceptance document, agreeing to be the trustee. You eliminate court intervention and court involvement.
Hey, Gary, I just want to step in for a moment because
Sure.
We had one question which I want to address, which is, what are the income tax reporting requirements of a revocable trust? A revocable trust, as Gary said, is still considered to be your alter ego. So if I create a revocable trust, the trust's tax ID number is actually my social security number, and all income that has to be reported because of any income earned by the assets owned by the trust are simply still reported on my individual income tax return. So there's no additional income tax reporting requirements for a revocable trust. There's no additional tax return while I'm alive, and there's no separate tax ID number. For income tax purposes, it's still considered to be me. But for purposes of probate or purposes of administration, it is owned in a separate vehicle that doesn't require as much court intervention. But what I did want to clarify, because as I look at the roster of of people who are on the line. I see a number of our clients, which is wonderful, some of whom are in New Jersey. And they may be listening to this thinking, why do I have a will and not a revocable trust? And I just wanted to reiterate that in kind of what I call normal circumstances, New Jersey probate is very, very simple, straightforward, and inexpensive. And having a executor appointed and a trustee appointed, typically in New Jersey, is very easy. What's making it difficult right now is really just the fact that the courts are, depending on the county, closed, if not, open, but not open to the public. So it's making it difficult to get the wills probated and actually have the people who are appointed as executors go to the court and sign the documents that are necessary. New York and Florida, their probate processes during normal times are considerably more difficult and time consuming. So for Florida, for many years, we've recommended revocable trusts. New York has been more recent, and that's really because particularly in the boroughs and in the city, we've just noticed in the last couple of years that the time and hassle of probate is just taking longer and longer. So I just wanted to just kind of reiterate that revocable trusts are not typically necessary in New Jersey, but especially now because trusts only require the grantor to sign in New Jersey, that may be a really good alternative for people who are concerned about having assets held up until the courts reopen.
Yeah, all good points, Mary. And in New York, for example, if because of the virtual notary law, someone can sign a revocable trust in New York. If they're the sole trustee of the trust, it could be virtually notarized, by one of us who are notaries. If the trusts get funded, that's a workaround for distributions of assets at death. And an important point in the revocable trust conversation is just ownership of assets, and just how the composition of your assets. Retirement assets, life insurance, those are assets that typically don't get put into a revocable trust because they have a beneficiary designation. And the fact that they're beneficiary designated assets means they're non-probate assets, which means they don't pass through your will, and you don't need an executor to be appointed to deal with them. So the important point with retirement assets and life insurance is whatever your estate plan is, whether it's a will, whether it's a revocable trust, what's in the revocable trust, those trusts, the subtrusts, and whether that's in the will or the revocable trust, it's crucial that the beneficiary designations be coordinated, they be consistent. And a simple example is if you've built in trusts for your children under your documents, and your retirement asset beneficiary designation just simply says your children outright, well, that's an inconsistency. We work very hard to make sure all assets are passing through to the same place, because we want consistency. The other point is, as it relates to revocable trust, is joint assets. So frequently when we're meeting with husband and wife, or in these times, talking with them or meeting with them virtually, we see a lot of joint ownership. And a joint asset, when one spouse dies, by operation of law, it passes to the surviving spouse. So again, that's what we consider to be a non-probate asset, with the idea that a probate asset is an asset that automatically passes through your will. So a non-probate asset is an asset that doesn't. A joint asset, again, doesn't need an executor to be appointed to transfer that asset to the surviving spouse. So in the conversation of revocable trusts or wills, one of the ideas and recommendations that comes up, because we see a lot of joint assets, is potentially doing the revocable trust after the first spouse passes away. But again, we're certainly, for New York and Florida purposes, as a matter of course and habit, using revocable trusts. New Jersey, not so much, as Mary said. Certainly in this crisis, a revocable trust in some instances would have been helpful. The New Jersey courts have been much better and quicker and less burdensome in getting executors appointed and trustees appointed to deal with the assets. Our last topic for today, the crisis has highlighted some opportunities for high net worth individuals. And this deals with sort of the tax aspects of estate planning. And the basic idea of where we are right now in terms of what the estate tax rules are. There's still a federal estate tax. It's a 40% tax on assets that you own or you're deemed to have too much control over. New Jersey eliminated their estate tax as of 2018. There is a New Jersey inheritance tax. Don't forget that. That's a tax on bequests to non-family members. So we don't see that too often, but it's still out there, and a lot of people don't. We hear the estate tax has been repealed, not the entire estate tax, just bequests to family members and spouses. New York still has an estate tax. Florida has no estate tax. And we work in Connecticut as well, and Connecticut has an estate tax. There's important exceptions to the estate tax. The first exception is something known as the unlimited marital deduction. And the idea there is unlimited amounts of money can pass to a surviving spouse estate tax-free. That's a federal rule, that's a state rule. The idea with that is the government wants their estate tax. They don't want it when it's passing intra-generation to a spouse. They want it when it goes down a generation. So the idea is, okay, we'll defer the tax when it goes to the surviving spouse. But when the surviving spouse dies, that's when we'll get the tax. The second exception is something known as the applicable exclusion amount. The applicable exclusion amount in 2020 is $11.58 million. That's the federal amount. The New York exemption amount is $5.85 million. The way the law is written right now, and who knows what that's going to be in years going forward, in 2026, the federal exemption is set to go down to a 5 million number subject to an inflation adjustment. So we're not clear on what the amount's going to be. But the idea right now is, from a federal point of view, a husband and wife have the ability to pass tax-free to their children approximately $23 million. The idea with planning, and this typically would apply to people over the $23 million number, is planning during life and gifting. The $11.58 million number not only applies to what you have, what you can pass at death, but that's what you can give during your life. So if you give 11.58 during your life, you've used it up during your life, and you have nothing available at death. Now, what's the advantage of giving during life? If you give 11.58 million today, if that $11 million amount grows to $30 million, all the appreciation on the $11 million gift is out of your estate. So appreciation is a big advantage to gifting during life. So with the COVID crisis, what we're seeing is asset values are now suppressed. So if a client had an asset worth $1 million in January, and we look at it today in April, and that $1 million asset is now worth $600,000. If the client is still interested in doing planning, if he were to gift today, he would gift the $600,000 valued asset. So if the $600,000 valued asset now grows to $1 million and even more, the idea is the appreciation from $600,000 is out of the estate. If the client gifted the $1 million asset at the, in December or January, and it went down, he or she still made a gift of the $600,000 value. Now, there are certain more advanced techniques that involve some of these gifting strategies, and the fact that interest rates have now dropped to almost record level lows, that also is now another opportunity to look at these techniques, because the low interest rates just enhance the value of the ability to transfer more assets. So one example is something known as a grantor retained annuity trust, or a GRAT. And the idea with that type of trust is a client transfers $1 million of assets to this type of trust. And the way this trust is drafted is, as long as that client gets back the $1 million of assets during the term of the GRAT, he hasn't made a gift. And the planning idea with the GRAT is whatever's left over at the end can pass to the beneficiaries, gift and estate tax free. So the way the GRAT's designed, the GRAT has to pay back the taxpayer not only the principal, but some interest. And the fact that the interest rates are so low, it's less of an amount of interest that needs to come back, making the GRAT a more attractive technique now during these times. The last technique I want to quickly review is a sale technique. We implement a lot of trusts and clients selling to trusts, where it makes sense to sell assets and not gift assets. And when you sell an asset to a trust, the taxpayer takes back a promissory note. And similar with the GRAT, there's some interest component to the promissory note. Because interest rates are historically low, the amount of interest coming back is much less than what it has been in the past, making these times an attractive opportunity for high net worth clients who are interested in more advanced planning. Mary, do we have any questions?
Yeah, we have a couple of questions. One question is someone who said that they have several couple friends who had to postpone their weddings because of the COVID virus, and that they assume that their significant others don't have the legal right to be with them in a hospital situation as a non-family member. Could a healthcare directive or other legal document be executed to rectify this, or is that not possible unless they are married? So a healthcare directive or a healthcare proxy, it's called different things in different states, is a document whereby you appoint someone to make medical decisions for you if you can't make them for yourself. There is no requirement that you appoint a family member. Likewise, family members, despite what I think a lot of people believe, just because you're married does not mean that that your spouse automatically has the right to make medical decisions on your behalf. You still have to name them in a healthcare directive. So you can name a spouse, you can name a friend, you can name another family member, you can really name anyone that you want, but it is important to have a healthcare directive signed, and that healthcare directive should have a provision in there that waives the HIPAA privacy laws, because if it doesn't, then the healthcare directive or the healthcare agent may be legally allowed to act on your behalf, but not allowed to talk to your doctor about your condition and certain other things that may be in your medical file that certainly you would want that person to be able to have access to in order to make an appropriate decision. So very important to have well-drafted, appropriate healthcare directives in place, whether you're appointing your spouse or appointing someone else.
All right, Mary, I see a couple other questions. Let's just address them. I see a question from Leah. You just said that $1 million was gifted in December. The grantor still gifted 600,000. Can you explain? All right, so let me just clarify. If a client made a gift of $1 million in December, let's just say it was $1 million worth of stock. He or she completed the gift in December. That's $1 million gift. If you fast forward to today, and the gifted amount is worth $600,000. That's what it's worth. You made the gift, you completed the gift in December, and it was worth $1 million at that time. If you did not and you waited, and you just didn't make the gift, but now that same amount of stock is now worth $600,000 today, and you decided to gift it today, the gift today is worth $600,000. So the advantage today of gifting is you're gifting at lower values with the idea that you think the market is depressed and low and it's going to go up. You get the benefit of more appreciation.
Okay, there's another question. This had to do with the beneficiary designations for an IRA. So the question is regarding a revocable trust. What do you do with an IRA from a financial company which asks to designate the people and percentage that will be given to your children? So as Gary had said, the retirement accounts and life insurance don't typically go through your will or your revocable trust, but instead there's a separate beneficiary designation that you filled out certainly when the account was open, and you may not have looked at it since. So if your intention with those assets is to name a spouse and then to name your kids as the contingent outright, then you don't even have to mention a revocable trust or a will on the form. You simply say primary beneficiary, spouse 100%, contingent beneficiaries, if you have 2 kids, child 1, child 2, 50-50. Where it becomes, a little more complicated in terms of the forms is where you want to name trusts, for example, trust for a spouse or trust that you've set up for kids under a will or under a revocable trust, then that language needs to be incorporated into the form. And, when we work with our clients and we create these documents for them, that's certainly something that we help prepare for them. So, the answer, like a lot of things, is it depends. But certainly, regardless of whether the beneficiary is a person outright or it's a trust that you've set up, all of that needs to be put onto the form for the IRA or for the life insurance policy.
Okay, Mary, I see a couple more. Let's just address them, and then we'll end the session. So someone wrote in, can a client use the sale technique without using his or her lifetime exemption? So the idea with the sale technique is you're not making a gift, right? You're selling assets to a trust. The typical rule of thumb with this type of technique is that because the trust is paying for these assets with a promissory note, that the trust needs to be somewhat creditworthy. So the goal is for the trust to have at least 10% of what you're selling the asset for. So if you're selling to a trust, if a client is selling an asset to a trust for $1 million, you'd want to at least gift $100,000 into the trust first. So the answer to the question is there should be some exemption and credit left to implement the sale technique. It's not generally advisable where you're selling to an unfunded trust and the trust is giving a promissory note. The IRS likes to see the trust to be a credit-worthy purchaser.
Okay. We have another question. In moving to revocable trust, what happens if you forget about some of your financial accounts? Are you still required to go through probate? So the probate assets, again, would be any assets other than assets that are jointly held with someone else with rights of survivorship, or have a beneficiary designation, which is typically the retirement and life insurance, and certain POD accounts at banks. So any assets other than those, so for example, real estate that's owned just by you, brokerage account owned by you, if you transfer some of those assets into the revocable trust, but you forget about transferring others, then what happens is, as to the assets you did transfer to the revocable trust, those will be available and accessible immediately after your death by the successor trustee. The will eventually would need to be probated to transfer anything that got left out into the trust, and you would have to go through, or the executor would have to go through that probate process. But at least there'd be some assets that would be accessible, and perhaps the delay in the probate process is less important, so long as there are at least some assets available for the beneficiaries or to pay expenses of the estate. So that was a good clarification.
Right, and then just the last few, Mary, and I'll just add just one bit of color to what you just said. In all of the estates we administer, and we're doing more revocable trusts now, it's rare that you're able to get every asset into the revocable trust. The idea with the revocable trust is to have at least some liquidity and some assets in the trust to handle the initial period of expenses where the other assets are tied up. So it's rare that we've avoided probate completely, because there's always some asset out there. If it's there are occasions where we are able to avoid probate, but in a lot of instances, the idea is to have the surviving beneficiaries have the ability to have access to at least some liquidity to deal with the initial expenses of the estate.
All right, there's two questions from different people, but they're related to the same topic. One is, what if IRA beneficiaries are minors? How do you title and direct to who or what? And then the other question was, are there adverse income tax consequences to naming the trust for kids as beneficiaries? And without going into, what could be another half hour of the very complicated rules regarding the income tax implication of retirement fund assets, suffice it to say that the Secure Act, which was a law that was enacted at the very end of December, that was effective January 1st, essentially eliminated, for the most part, the ability to leave retirement account assets to children or to certain trusts for their benefit, and get the ability to stretch out the income tax over the child's lifetime. So under the old rule, if I died with a retirement account and I left it to my child, then she would have her remaining life expectancy to take the assets out, which would only further stretch out the income tax liability over her remaining life expectancy. The Secure Act, again, with certain limited exceptions, has gotten rid of that ability to stretch. And the general rule now is that a beneficiary of a retirement account, other than a spouse, has to liquidate the account within 10 years of the person's death. So whether you're leaving assets outright to a child or you're leaving assets to a trust for them, if that trust is properly drafted, and I'm not going to get into what that means because it's very technical, and I don't think really a little bit more detailed than we wanted to get on this seminar. But if it's properly drafted, you can also get the ability to have that 10-year stretch period under a trust for a child as well. The difference, though, is if the trust is a beneficiary, the trust is liquidating the IRA, and the proceeds will stay in the trust. If you name your kids directly, it will be in the name of your kids. So depending upon how old the kids are and their circumstances, one certainly may be preferable over the other. We wouldn't recommend naming minors directly as IRA beneficiaries. We would recommend naming a trust for them. But if you don't have a trust set up under a will or revocable trust and you name the minors, likely what would happen, and I think it would depend upon the rules of each bank, but likely what would happen is it would be put into an account that would have a guardian until that child was either 18 or 21. So someone else would control those funds until they reached adulthood.
Okay, Mary, last couple then, we'll sign off. Just someone asked, there's no estate tax in New Jersey as long as it is to a family member. Are siblings and nephews considered a family members? The answer to that is no for New Jersey inheritance tax purposes. Siblings, a bequest to a sibling, I believe there's a $25,000 exemption, but anything above that amount is subject to 11 or 12% tax. And nephew, a bequest to a nephew, I believe is subject to a 15 or 16% tax. So
right, with no exemption. So that's from dollar.
with no exemption, yes. I just see another one, last few. What happens if assets you want to put into a revocable trust has debt attached? If you have a home or an apartment and there's a mortgage attached, you can do it, but you want consent from the lender. I'm sure there's a due on sale clause, so which says you can't transfer ownership. So there shouldn't be an issue with that, but that does add a little layer of administrative hoops to go through to do it. But there shouldn't be an issue with that.
Okay, and the last question I see is, can an IRA name a donor advised fund as beneficiary? And the answer is yes, and we didn't really touch on it, but certainly if you or a client are charitably inclined, the IRA is a great asset to use to leave to charities or to a donor advised fund or to some other charitable entity, because the income tax that's inherent in IRAs is not paid by the charities. So you get the benefit of gifting to charity, and you can give the IRA assets to a charity and the charity gets the full amount. And then you could give other assets to children or other beneficiaries that don't have that inherent income tax liability embedded in the assets. So the answer,
Right, if there's a choice, right, Mary, if there's a choice between, dollars to a charity or a retirement plan to a charity, you'd want to name the charity as the retirement plan beneficiary for those reasons. Because if you name the individual beneficiary as the beneficiary of the IRA, there's inherent tax in that.
for sure. All right, well, I don't see any more questions right now. We're going to leave this last page up. If you have any questions or want to talk about any of the things that we brought up or anything related to estate planning, feel free to reach out to myself or to Gary. We also have a COVID resource center, and we have a team of people across all of our disciplines, whether it's corporate, whether it's bankruptcy, to whether it's real estate, to discuss issues that may come up depending upon your unique circumstances. So feel free to reach out to us or to any of them directly. And if you have any questions after the fact, we're certainly happy to answer those as well.
Stay well and stay safe.
Bye, everybody.